All right, sir. Are you Herbert Kane? Is your name Herbert Kane?
Yes, ma'am.
And I'm going to take judicial notice in Mr. Kane's file. Mr. Kane was evaluated for competency to stand trial by Dr. Rapon. I've received that report dated August 13th of 2024. Dr. Rapon made the finding that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Parker?
There you go.
Ms. Malfino? Then at this time, I am going to find that Mr. Kane is competent to stand trial.
What you're about to witness is courtroom tension at its peak. Mr. Herbert Kane is staring down a second-degree felony charge for allegedly assaulting a peace officer. But this case isn't just about guilt or innocence. It's a mix of confusion, frustration, and pressure, all under the shadow of a 5-year plea deal that's about to expire. Watch closely.
Mr. Kane, you're charged by indictment with the offense of assault on a peace officer, and that is from April 3rd of 2024. And what that means is if you go to trial and a jury finds you guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand what could happen if you go to trial and you're found guilty?
I understand, but can I ask you a question?
Sure.
I got, I guess, approached for camping out, but I wasn't there overnight. I just came back from the store.
So here's the thing. What happened surrounding this offense or what they charged you with, that's information for your lawyer. And if for some reason if you believe you're not guilty, then that's what a jury's for, and we can let your case go to a jury. That's what we're going through. So it looks like the state has made an offer if you wanted to enter a plea of guilty for a 5-year term in prison. You have every right to reject that. Let a jury decide 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, then they can decide what your punishment is. Do you understand?
I understand, but as far as it being my first offense, I don't want to get that.
Here's the thing. Well, here's the thing. The offers, I don't get involved in the negotiations. That's not part of my job. So the state has made their offer. If you want to take it, you can take it. If you don't, then you let a jury decide. And so I just want to make sure you understand if you go to a jury, what your options are today and what your consequences could be if you go in front of a jury.
And Your Honor, I've discussed these facts that concerns he's had with Mr. Nichols, and explained to him the situation after he's had evaluated again to talk to about the offer, and Mr. Nichols has remained steadfast on the offer that he's made previously, which is the offer today.
Here's where everything starts to unravel. Kane wants answers, but the judge is watching the clock. The DA's offer isn't changing, and tensions are rising fast. He's trying to make sense of his past conviction, but no one's taking the time to explain it clearly. And in court, that kind of confusion isn't just frustrating, it can cost you years of your life.
You're aware it's not his first offense, it was actually before you in 2018. Okay.
So they think for
Burglary of a building, it sounds like.
the state jail felony was
Mm-hmm.
it was dismissed.
I've gone over it.
Okay, so it doesn't appear that it was dismissed, but I just want to make sure right now we're talking about this case. The offer is what the offer is from the district attorney's office. So you either take it or you go to jury trial.
I was telling them as far as what she says about
Look, regardless of that, that doesn't change. Even if you had it, it doesn't change the punishment in this one. Okay, that can be figured out by your attorney. It's not what is enhancing you. It's not changing this. The offer is what the offer is. Do you want it or do you want to let a jury decide?
How much back time?
Well-
I've discussed that with him this morning, Judge.
Okay.
He has approximately 100 days.
So
credit
hang
for
on a
time in
second.
jail.
You're asking me questions that your attorney has already gone over. Listen, don't talk up. Don't talk over me. Listen. Listen and don't talk for a minute, because I don't think you've been listening to Mr. Parker. Mr. Parker sounds like has explained everything to you. He's asked the clerk. She has figured out your time, how much credit you have. I don't know how much time. He doesn't know how much time you would actually do on a 5-year sentence because it depends on parole and good time and all of that and how you behave in prison. It's a 5-year sentence. You would be eligible for parole after a quarter of it. That's all we can tell you. And he can tell you.
This isn't just a legal debate, it's a power play. The judge has stopped explaining, the DA won't back down, and Kane's still trying to wrap his head around it. That 1244A. It's a Texas law that lets you serve a felony sentence in county jail instead of state prison. Sounds simple, but without a clear explanation, it's a maze, and no one's handing out a map.
So here's the thing. I went to law school because I'm not good at math. I have no idea. Well, do the math. I don't know. I mean, it's a quarter of 5 is
About a year.
3/4.
About a year and 3 months.
So you know.
I was trying to make sure.
Well, we're not here for a math test. Do you want to take the deal or do you not want to take the deal?
He asked me today, Judge, if he would get out if he took the deal. And I said you would not get out
No,
today. And
you don't get out today. You got to go get your number and do all the stuff. Mr. Parker's answered all this. I got other stuff to do. Do you want to take the deal or do you not want to take the deal? It's not going to be on the table after today. If you're either going to have a jury decide, which is fine, or the deal is going to be higher, not lower. Do you understand? And I'm not doing this to just for everybody on the trial docket. If you want a jury to decide, fine. You want the 5 years? Take it today, because after today, 5 years is gone. What you want to do?
Let's see. So you pretty much told me in so many words that you weren't going to allow me to beat my case.
No, I'm completely going to allow you to beat your case. If you want to take it to a jury, 100%, we're going to get it set for trial, and you'll be up for trial whenever the next available trial docket is, and a jury can decide if you're guilty or not, and if you're guilty, then they can sentence you to.
This line right here, I went to law school because I'm not good at math, I'd get a laugh. But if you're the defendant trying to figure out when or if you'll ever get out, it hits different. It's not just cold. It's revealing, a system isn't designed to make sense to the people trapped in it. It's designed to keep the machine moving.
The initial, I mean, it just goes on the trial docket with everything else. And as soon as it comes up, if it's number 1 that day, it goes. It depends on how old the cases are. It depends if somebody's in custody. It depends what type of case it is. So I can't guarantee you when your trial will be. I would like to think it would be, a year or less, but I can't for sure tell you that. We're doing really good with moving trials. Do the best we can, but
And now, the pressure hits. The judge lays it out. This is your one shot. After today, the deal's gone. No sweeter offer, no extra time to think, nothing. It's take it or leave it. It's that energy is real, and honestly, it's kind of terrifying.
when that would be.
Question, but what's not obviously on that brother on a.
We're not going back to that. Just let me know. We're not. No, we're not going back to a burglary. Okay. Do you want the deal on this one, or do you want to go to trial?
Huh?
Do you want the deal on this one, or do you want to go to trial? We're not talking about the other case again.
What's it to do?
All right. I'll hold it while y'all go. You need to do the paperwork with Mr. Parker this morning, and then I'll take care of it in a few minutes. No, if you're not, no. If you plead not guilty, then you go to trial. You're either going to say you did it or you didn't do it.
I didn't do it.
If you didn't do it, then we're going to set your case for trial. So we're going to put your case on the trial docket. And so, Mr. Kane, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. If, with your permission, I can release him and I can appoint another attorney today who can start getting ready for trial a little quicker. Is that okay with you? You're going to get who I give you. You're going to get whoever is on next up on the list. So it's probably not going to be him. Okay, he's not on our list anymore. Yeah. All right. So is it? Do you want to keep Mr. Parker, or can I give you another attorney? Okay. Mr. Parker's released. We'll give you another attorney.
In the end, Kane says what so many defendants do: I didn't do it. And just like that, the deal vanishes. His lawyer's off the case, and the countdown to trial begins. Guilty or not, you can feel how fast it all shifts, how high the stakes really are, and how little space there is to simply breathe.